Hi, my name is Alex Dolphin and welcome back to another episode of Ex Ante. Today we're going to discuss the case Piper Aircraft v. Reyno. This case was heard in the Supreme Court of the United States in the year 1981. Let's go ahead and jump into the facts of the case. So the plaintiff is Reyno. Reyno is an administrator of the estate of some people that died in a plane crash. This plane crash occurred in Scotland, but Reyno filed suit for wrongful death against the plane company that manufactured the plane that was involved in the plane crash. She filed suit against two key defendants that we need to know: Piper Aircraft, which is the ultimate plane manufacturer headquartered in Pennsylvania. She also filed suit against a propeller manufacturer headquartered in Ohio. Now, she filed this lawsuit in a California state court. Both Hartzell, which is the propeller manufacturer, and Piper, which is the plane manufacturer, moved to remove this case to a United States District Court. The court granted that motion for removal, and then the defendants moved to transfer the case to a Pennsylvania U.S. District Court, which is where Piper Aircraft is headquartered. The court also granted that motion. Hartzell was a little bit concerned about being in a Pennsylvania United States District Court, and they argued that, hey, we're not subject to personal jurisdiction in the state of Pennsylvania. We're an Ohio manufacturer, and we don't have any minimum contacts with Pennsylvania that would subject us to personal jurisdiction in that state and in the federal court of that state. That argument was successful. So Hartzell was successful in arguing that they're not subject to personal jurisdiction in the state of Pennsylvania. So now both defendants made a move to dismiss the case on grounds of forum nonconveniens. Forum nonconveniens means that a court can use its discretionary power to refuse to hear a case if a more convenient or just forum exists elsewhere. Now, the court granted this motion. They dismissed the case, the district court did, on grounds of the case would be more convenient and more just if it were heard in Scotland, in Scottish courts. Now, main reason to know why these defendants would rather litigate in Scotland than in the United States is that Scotland does not recognize strict liability in tort law, whereas the United States does. So they would have an easier case in Scotland to defend themselves than they would in the United States. Now, the court, when it granted this motion for dismissal upon forum nonconvenience, the court considered public and private factors. This is considered the Gilbert Test. Now, the Gilbert Test considers the private factors, and when the court did that, they figured that this case would be more easily heard in Scotland. There were witnesses there. This case probably occurred because of the topography in Scotland as the pilot was flying low. It just makes more sense to litigate this in Scotland. That is the site of the accident as well. Now, the public factors, the court says why it makes more sense to litigate in Scotland, is because Hartzell's not subject to the law of Pennsylvania. So they would be applying, the district court in Pennsylvania would be applying United States law to Piper, but they would be applying Scottish law to Hartzell. So they said this is really difficult. It's probably going to be ultimately very confusing to a jury to have, two defendants in the same case where you're applying, Scottish law to one and then United States law to the other. So the court ultimately granted the motion. The appellate court here, for the third district, actually reversed this case. They reversed and they said that the dismissal on forum nonconvenience was improper. Now, the appellate court says that when a plaintiff is going to be subject to law that is less favorable to them upon a movement of forum nonconvenience, then that motion should not be granted. The appellate court placed a high emphasis on the import of the plaintiff's choice of law. And if the plaintiff would have been negatively impacted by a transfer, essentially, transfer to, and that's loaded terms, but a movement to another court, then the court couldn't dismiss on forum nonconvenience for those grounds. And the court said, we're not even going to get to the Gilbert factors of private and public fairness because the plaintiff is so high here, and the plaintiff's right is so high and recognized here that we're just going to reverse the role of the district court because the plaintiff would be subjected to worse law if they moved to Scotland. Now, the United States Supreme Court actually sides with the district court, and they reverse the opinion of the appellate court. They say that the dismissal based upon the grounds of forum nonconvenience was proper, and the appellate court erred. Now, they talk about how, yes, there is an interest of the plaintiff, but because these these plaintiffs were foreign citizens in the first place. They're Scottish citizens in the first place. They're not United States citizens. The emphasis placed upon these foreign citizens is not as high as it would be upon the United States citizens. So we're not going to give as much deference to the place where they filed the lawsuit because they're foreigners in the first place. They're not United States citizens. The court also says that it was improper for the appellate court to not consider the Gilbert factors. And any time that you're going to be doing this, yes, the right of the plaintiff is important, but you ought to consider the Gilbert factors. And they go ahead and reify what the district court said, that the Gilbert factors point right in the direction of dismissing this case in the United States and having it be heard in Scotland. The witnesses, the accident was there, and that's actually where the plaintiffs live and reside and are citizens of. For public and private interest, the public interest being that it'd be really hard for a court to apply Scottish law and U.S. law in the same case. Well, so in that instance, it was proper to dismiss this. This case should be heard in Scotland. These are foreign plaintiffs. This is a foreign accident. We'd be applying foreign law in the United States if we heard this here. And for those reasons, really is much more convenient for this case. It's going to be much more just if this case is heard in Scotland for both the plaintiffs and the defendants. So it's an interesting case to think about. And these are United States companies. You might feel like they should be able to, they should be forced to litigate on their home turf. But where the accident occurred in Scotland, the witnesses are in Scotland, you can see the competing factors there and why a court might feel that it would be better for a Scottish court to deal with this case. But thanks so much for watching, and I hope you enjoyed this video. If you'd like to see more, go ahead and hit that subscribe button, and I hope you have a nice rest of your day. Bye-bye.